So one of the things that no one talked about when they were talking about the settlements between the banks and the institutions and our government, the 49 state attorney general and the Office of Comptroller and Currency settlement, was the fact that the net result of the settlement was going to be faster foreclosures and throwing people into the street more quickly than before the settlements. I'm seeing that here in the office in a very dramatic way. Our typical client had been someone who'd just gotten served, but now increasingly the clients that are coming into this office are folks that might have gotten served in 2009, 2010, but are now getting notices for trial or summary judgment. And this comports with what I see in the courthouse, where entire boxes are being brought, files are being brought into courtrooms, and they are pursuing those files, going through them, and then setting them for trial. Now, I've got a real problem when the court is unilaterally reviewing cases and then setting them for trial. But the bigger picture is that the terms of the settlements reached between the banks had it that the money that was paid by the banks and institutions was supposed to be used to quote-unquote help consumers. Well, here in the state of Florida, at least $5 million of that money is being given to the counties in the court system, and that money is being used to set up these rocket dockets and flush cases through the system more quickly. So I question how it is that that money, which is making a direct transmit into our court system and is being used to set up special dockets for the foreclosure judgments, is actually helping consumers. It's just not. Now, if a consumer were able to walk into a courtroom and get fair treatment, I suppose it might be a little bit not as bad. But the fact of the matter is that, unfortunately, walking into courtrooms in these foreclosure trials, and it's not fair to call them trials because in many cases they're just ambushes, but the perception that a foreclosure trial, a homeowner doesn't have any defenses, is unfortunately too widely held. And so you walk into courtrooms. I've talked about this trial I witnessed recently where, a defense attorney made like 100 objections, and every single one of them was overruled. Now, if any attorney from any other area of the law walked into one of these courtrooms and listened to these objections that were being made, they would be flabbergasted because, the objections that are being raised by proper defense attorneys to the testimony of these robo-perjurers should absolutely be sustained, and it would force the banks to go back and reorient their procedures. The fact of the matter is that the procedures set up the bank that exist even to this day are still fatally flawed, and they have not corrected them. But again, why should they? They have not been held to account by the government at the federal level, certainly not at the state level, and unfortunately, it's not occurring down here in the circuit court at our trial level. It's a disturbing circumstance out there, and far too many consumers who've been living in their homes under a false sense of security, maybe they've even been in a modification, are going to get caught in the chainsaw of these foreclosure trials that are being set. Now, there is one other thing that we've stumbled across here that we've been using for a number of months that is an absolute defense to many foreclosures. I haven't talked about it yet publicly and won't, but I can tell you it's extraordinarily significant. It has a statewide, perhaps a national significance, and it's an absolute bar to foreclosure in many, many cases, and has a much bigger and broader public purpose impact. Now, that's something that we'll be fleshing out in a variety of private channels, but the fact of the matter is that consumers need to be interfacing with good attorneys who know what they're doing in order to take advantage of some of the remaining defenses that are out there. If you're not, and you're going into trial, you get a notice of trial, then you're certainly going to be in trouble. And the fact of the matter is that even if you haven't gotten a notice of summary judgment or notice of trial, if the preparation work, the affirmative defenses, the complaints, and the other things, if that's not done properly at this point in time, and you start getting notices of summary judgment or trial months down the road, you're simply going to be left entirely vulnerable and unable to defend yourself and unable to make those affirmative defenses. And so far too many good people that shouldn't lose their homes are going to because they haven't taken advantage of this time and haven't gone out and found themselves good attorneys who know what they're doing. So the message is simple. Defend yourself properly. Get an attorney that can be with you in court. Defend that foreclosure case.